We are now recording.
All right. Well, welcome everybody to our 6 of 7 summer trainings. Today we'll be talking about disability rights, workers' compensation, and COVID-19. Wanted to let you all know that this is a recorded webinar, some accessibility notes. You are automatically on mute, so don't unmute yourself. If you have anything you need to tell us, please tell us through the chat box. If you need closed captioning, there should be 2 double C somewhere around right here at the bottom of your screen. If you click that, you should be able to turn on closed captioning. I will be your moderator, myself and Karin from WorkSafe, and we'll do our best to make sure this runs smoothly. We will be asking the speakers to speak slowly so that, or at a good pace, so that the closed captioner can also capture what you're saying at the same time. And Karin, you wanna talk about this real quick, the evaluation?
Sure. So for people who would like MCLE credit, you are required to take a survey at the end. When you click exit on the Zoom, your browser will open up a tab in whatever internet browser that you're using. So check the tab, and then there you would select, it'll say, are you sure you want to continue? Select continue. It will bring you to the MCLE evaluation form. But we would like everybody to give feedback about the presentations. It helps us figure out how we can better tailor and present our trainings to you. And so we encourage everybody to give feedback. Those seeking MCLE credit are required to take it.
All right, thanks, Karin. And Karin is the amazing coordinator of this entire series. We are in number 6 of 7, and if you missed any of the prior 5, we, as I said, are recording them, so you can access them at a later date. We'll send out an email to let everyone know in case they missed any, and feel free to email us, email Karin, and I'll give my email at the end. If you have further questions about any of the situations you may be experiencing in the workplace. So today our presenters will be Rachel and Cheryl, and I'm going to ask them to come back briefly to introduce themselves to you. I am Jora Trang. I'm the Chief of Staff and Equity at WorkSafe. My pronouns are they, them, their, she, her. And Cheryl, why don't you pop in? And I don't need to have the their image on, right? It'll pop up naturally for the Zoom, for those on Zoom.
Yes.
All right, great. So come on back, Cheryl.
I'm here. Good afternoon, everybody. My name is Cheryl Wallach, and I am a partner at Ford & Wallach, and all we do is practice exclusively workers' compensation. I am a true believer in the workers' compensation system. I am on the Board of Governors for the California Applicants Attorneys Association and on the board of WorkSafe as well. And thank you for the opportunity to speak.
Thanks, Cheryl. Rachel?
Hi, I'm Rachel Langston. I am a senior staff attorney with Legal Aid at Work. We're based out of San Francisco, but we help workers throughout California. And a lot of what I do is working with people who may need reasonable accommodations at the workplace and who've been denied, who've been subject to disability-based discrimination. And we do direct advocacy with employers. We do brief advice and assistance, litigation, and we do also provide technical assistance to people who work with workers with disabilities, so service providers, healthcare professionals, worker advocates, etc. So we are happy to be available to any of you for that purpose, and to, of course, any worker with a disability that needs assistance. And I will just briefly say Legal Aid at Work also offers a number of different programs. We have a race equity program, gender LGBT, wage and hour. So there's a lot of stuff there. So feel free to take a look at our website. And if you're having, or you know someone having a workplace discrimination issue or something similar, feel free to give us a call.
All right, thank you, Rachel. So think we're gonna, I'm just gonna give you a little bit of background on us. Many of you have been joining us, so thank you for returning. If you're new to us, WorkSafe is a nonprofit that's based in Oakland, but we are statewide, and we focused on trying to prevent injuries, illness, and death in workers by focusing on increasing worker power, working with worker centers and worker organizations and advocates to ensure that workers' voices are amplified. We advocate for policy change as well to make sure that workers have the most protective law possible. And then we make sure that there's enforcement of those laws. What good is good laws if there's weak enforcement? We also raise awareness about occupational safety and health through trainings, capacity building, and direct coalition work. So feel free to browse our website. We have resources and information on our current campaigns on the website, and we are actively engaged in coalitions. So if you're not already a part of our coalitions, please contact me. We'd love to fold you up into that. So Karine is going to launch a quick poll. We want to know who's here so that the trainers can have have a feel for who's in the room.
So yes. So who do we have here today? I just launched the poll. Thanks for participating. Okay, maybe a few more seconds to get more votes in. Okay, we're at close at 80% as I could get. So thanks for sharing. We have we actually have a lot of attorneys here that have experience and also worker advocates. Feel free to share in the chat if you like what you do and where you're located if you'd like to. And then we also would like to know what you have the most experience in related to topics we will discuss today. Feel free to choose more than one. Let me get that started. Okay, it should be up on the screen now. Welcome, Trabajadores Unidos, Workers United in San Francisco. Okay, let's get a few more votes in. Okay, so it looks like the most we're gonna get, it looks like, you know, kind of consistent with who we had here today. Organizing and worker advocacy experience, employment law experience, and then people here to learn. Thank you so much for engaging in these polls.
All right, thank you everyone. All right, so we're gonna, what we're gonna cover today is disability rights at work, workers' compensation rights and benefits, and we'll try to leave some time for question and answer. And I think I'm gonna jump right into Rachel's presentation. Rachel, I'll invite you back.
Hi. Sorry, having a few technical difficulties. Can everybody see me?
Yes, we
We
can
can see you.
Okay, great. Sorry about that. Yeah, so I'm going to talk a little bit about some of the issues we're seeing and strategies that we have for workers who have disabilities, especially because there's a lot of new situations that are coming up at the workplace during COVID times. And so we've worked a lot with workers on these various issues and want to kind of, one, give you a baseline for general disability rights at work, and then talk about how they apply during COVID-19. Next slide. So a little bit more about legal aid at work. As I said, we have a number of various programs The Disability Rights Program advances the rights of people with disabilities, not only in employment, we also work on education issues, especially higher education, accommodations in higher education, and public services. We provide, in addition to advocacy, brief services, information, individual litigation, and class actions, and we also do education like this. We were founded in 1916, and importantly, we provide free legal advice and information through toll-free helplines and clinics. We have a disability rights helpline, and then here in a month or so, we'll be starting up our disability rights virtual clinic, which is active throughout the school year, staffed by law students who are supervised by attorneys. Sorry, next slide. Thanks. So I'll jump right into it. What laws provide protections for workers? Some of this may be old news for many of you, but again, just a brief overview, a reminder for those of you and maybe new to others. So the Americans with Disabilities Act is, of course, the big one that provides protections. We'll talk about what those are. And that applies to employees that have at least employers that have at least 15 employees. There's the Federal Rehab Act, which is more limited to federal employers and federal contractors, other recipients of federal funds. It's very similar in terms to the ADA. And then of course in state law, we have the Fair Employment and Housing Act. We'll talk in a moment about how that's a little different than the ADA. And California Government Code, Section 11135, which is basically the state version of the Rehab Act because it governs state-funded employment or state employers. So as I said, under the ADA, an employer has to have 15 or more employees to be covered under that act, but they only have to have 5 to be covered under the FEHA. So people with relatively small employers are still protected against disability discrimination, failure to provide reasonable accommodations, etc. under the FEHA. Notably, the FEHA does not cover religious employers. The exception is hospitals, which often have a religious affiliation, but otherwise they are not covered. The ADA might, unless the ministerial exemption applies. Some of you may be familiar with the Lady of Guadalupe case recently decided by the Supreme Court, which sort of broadens that exemption, unfortunately. So we'll sort of see how that starts to apply. But basically, if you have any sort of ministerial religious duties at your work, then the ADA probably does not apply to you, unfortunately, and that's the case for other civil rights laws as well. The Rehabilitation Act and Section 11135, there's no minimum number of employees required. So what employees are covered? First of all, you have to be qualified. You have to meet the minimum requirements of the position, have the skills necessary to, background necessary to perform the job. You have to have a disability. We'll talk more about what that means. And you have to be able to perform essential functions of the position with or without reasonable accommodations. So essential functions are basically things that are really tied to the job, that they're sort of the purpose of the job. There's something you do all the time with the job. And courts look to a number of different factors to figure out whether something is an essential function. One thing employers like to do a lot is to list everything under the sun as an essential function so that they can get out of having to accommodate employees by reassigning a task or something like that. But a job description is not the end-all be-all when it comes to essential functions. Courts also look to employers' judgment, how much time an employee spends on a particular function, have past individuals who've held the position or other ones, other incumbents do that task. And is it addressed in a performance review? Is it something important enough that it comes up in that arena? So there's a lot to look into it. So I never accept an employer's word for it when they say that something is essential. So what is a disability then? There are basically 3 ways that you can fall, well, actually technically 4, that you can fall under the protections of these laws. The first is to have a mental or physical impairment that substantially limits one or more major life activities. So that basically means first of all, after the ADA was amended in 2008, it made very clear that the definition of major life activities is very broad. So it's anything from walking, talking, concentrating, sleeping, to things like the bodily system. Your respiratory system, is substantially limited. Neurological system, reproductive system, things like that. So it's a pretty broad definition, and that's intentional. Congress made it clear that it was intentional when they amended the ADA in 2008. You can also have a record of such an impairment. So if you were disabled in the past, but are no longer disabled, if you're completely in remission from cancer, but you're discriminated against based on the fact that you had cancer previously, that would be a record of such impairment. And then finally, if your employer regards or perceives you as having such an impairment. So you may not have a disability at all, but they, for some reason, assume you do and treat you differently because of it. You also have some coverage under the ADA. So we talked a little bit about this, what has come up under the 2008 amendment. Other changes that have been really clarified are the fact that the law also includes, in its definition of disability, disabilities that are episodic or in remission. We talked about cancer, things like asthma, things like migraines. They are counted or can count as a disability if they substantially limit a major life activity when they're active. So if you have recurrent migraines and you happen not to have a migraine today, that doesn't mean that you don't have a disability today. You do, it just is not currently active, but when it is active, it substantially limits your activity. So there are some conditions that are virtually always considered a disability. Some examples are there, we've talked about some, but epilepsy, diabetes, cancer, HIV, bipolar disorder, and clinical depression. So mental and physical disabilities are covered under the ADA and also the FEHA. We talked about regarded as, and it also is a focus on how the person has been treated. So if the employer treats them differently and takes actions or makes comments that leads them to believe it's because the employer thinks they're disabled, it doesn't matter if the employer says, no, I didn't think that. If their actions suggest that they did and they treated someone poorly because of it, that is what's looked to establish that someone is regarded as disabled. And another important thing that was clarified under the Amendments Act is that courts no longer consider mitigating measures. So the Sutton trilogy of cases that came out shortly after the ADA was enacted in the early 90s did a lot of unfortunate things, including limiting, saying that conditions that are episodic or in remission are not always necessarily disabilities, and things like that. Another thing that these cases unfortunately held, or the Sutton case in particular, is that if you have a disability but it is mitigated by something, medication, a prosthetic, if you have diabetes and you're using insulin, then you're not disabled if you have something that mitigates that disability, which of course was not Congress's intention, and they really clarified that in 2008. So the FEHA is fairly similar to the ADA. It does only require a limitation as opposed to a substantial limitation. This can be helpful sometimes, but generally they're pretty similar, treated pretty similarly. I think sometimes when this comes into play is if a disability is of shorter duration. there are arguments to be made that even a very short-term disability can be a disability under the ADA. Sometimes that argument is easier to make under the FEHA. Also, that California government code there lists, again, some of the disabilities that we talked about, but it actually codifies some of those disabilities as being disabilities under state law. Okay, so let's get into COVID. We've had this come up a lot. Is having COVID a disability under the ADA and FEHA? As those of you who are lawyers or who have talked to lawyers know, our popular answer is it depends. Also a very frustrating answer, but it does. And there are a few things to keep in mind. If someone is asymptomatic, they have COVID, but they're asymptomatic, or they have symptoms, but they're just the symptoms of your, standard flu or cold, that alone is unlikely to constitute a disability. So that is sort of where we are now. Now it's interesting because, of course, there are studies being done about whether even having asymptomatic COVID has any sort of long-term impacts on your health. So that may sort of shift and change that definition. But for now, that's kind of what seems to be the case, because the law is clear that if you have the cold, if you have the flu, that's not a disability. So if that's how COVID presents, it's unlikely a disability. However, if COVID results in more serious complications like pneumonia, any sort of organ failure or anything that is kind of a COVID, quote unquote, COVID complication, that may constitute a disability, again, if it substantially limits a major life activity. I thought I had a slide on this, but I want to just go back to COVID briefly, because and watch, I'll have a slide later, but other things that have been coming up as far as definition of disability, or COVID and disability. We get a lot of calls from people who have underlying health conditions like asthma, who are worried about having to go into work because if they know that if they contract COVID, they have a higher probability of having some really serious consequences. So what do those people do? Many of those, I would say most, if not all of those underlying conditions would constitute a disability under the law. Asthma, diabetes, cardiac issues, even sometimes high blood pressure. So in those cases, and we'll talk more about reasonable accommodations, but you might request reasonable accommodations at your work, either for different or more protective gear, or even the ability to telecommute, or worst case scenario, a time off from work for a period until we hopefully get this under control. So we will talk more about accommodations momentarily. So what protections are available under the ADA and FEHA? First of all, you can't discriminate against someone in the terms, conditions, or privileges of their employment. So this means anything, it kind of speaks for itself, but as far as fringe benefits, anything like that, you can't treat someone with a disability differently because of their disability. You can't harass someone, you can't segregate someone, physically or otherwise. People have the right to reasonable accommodations, which again, we'll talk more about. You can't, this is an important one, and I mentioned sort of a fourth prong to the definition of disability. You can't discriminate against someone who associates with a person with a disability. Where does this come up a lot? Parents who have children with disabilities, and their employer finds that out, and so maybe the employee is up for a promotion that involves travel, and because their employer knows that they have a child who's in and out of the hospital, they say, well, I'm not going to put you up for this promotion because I know that you have to, take time off a lot to go to the hospital for your child. That's not required. An interesting area of law that's sort of developing is whether you have to provide an accommodation to someone that associates with someone with a disability. So would you have to provide an accommodation for someone who technically themselves doesn't have a disability, but lives with someone or cares for someone that does? The law is not very clear on that yet. There is some case law that's come out that suggests that you might under the FEHA, but it's still very tentative and by no means settled law. The ADA and FEHA also restrict medical inquiries. We'll talk more about that. And you can't retaliate against or interfere with someone who tries to assert their rights under these laws. So back to what are reasonable accommodations? This is any change to how the job is done or where the job is done that makes it possible for an individual with a disability to enjoy equal employment opportunities, have the same chances at trainings, promotions, etc. at work, perform their essential functions. We talked about what those are. Again, to be qualified for a position, you don't have to be able to perform the essential functions without an accommodation. As long as you can perform them even with accommodation, you would qualify. So for instance, if an essential function is lifting heavy boxes onto a truck, you ordinarily could not do that without any sort of assistance, but there's a particular lift you can use that even with your disability, you're able to do that, you are qualified for the job because you can perform that essential function with accommodations. And then finally, they're necessary if needed to enjoy the same benefits and privileges of employment as are enjoyed by non-disabled coworkers, like trainings, the break room, etc. One example of this coming up is I, years ago, represented a deaf client, and his employer had finally gotten around to providing him an American Sign Language interpreter for various meetings with HR, etc. But then they had a big barbecue at the end of the year for the whole company where there were speeches and awards were announced, and it was a morale building activity. And the employer said to us that they didn't feel like they needed an accommodation for that. But again, morale building is a benefit and privilege of employment that everybody is entitled to and needs. And so that was something they should have provided, that accommodation at the barbecue. Next slide, please.
And then Rachel, we just have a question that I think goes with what you were talking about, I think a slide before that, which is if you could repeat or explain again what is considered association.
So association, it's fairly broad. Like I said, I think the most common area where that would come up would be if you had a family member, child, spouse, etc. with a disability. But it can be even broader than that. It can be if you have a friend with a disability, or supporting a coworker with a disability, and you're discriminated against because of that. So it is a pretty broad definition. And I talked about this a little bit earlier. I may have jumped the gun like I was worried I would. But again, what are reasonable accommodations in the time of COVID? First of all, who can get them? If you have become disabled due to COVID, for instance, experiencing a COVID-related complication like pneumonia, heart disease, etc. Or if you have a disability that puts you at high risk, like I mentioned before, diabetes, autoimmune disorders, disabilities that affect breathing. That's been a big thing I've been hearing from people about, is they're really worried about going to work and contracting COVID and then having a really bad complication because of their disabilities. And they're entitled to accommodations for those underlying disabilities in order to stay safe. And we'll talk more about what those can look like. Next slide, please. So what are examples of COVID-related accommodations? again, the ability to work from home. It's interesting because pre-COVID times, it was very, very difficult to get this accommodation. Employers would swear up and down, there's just no way that we can do that. That's not reasonable. It would be an undue hardship. It just is way out of what's possible. Suddenly, everybody's working from home, or not everybody, but a lot of people. And employers have figured out that, hey, this is actually doable. So I think the disability community, if there's any small silver lining to all of what is going on, I think it has been made pretty evident that it is doable to set up a telecommuting workspace for employees. So that's a big one. As I mentioned, additional or modified personal protective equipment, changes to environment, like one-way walkways or erecting barriers, temporary elimination of non-essential functions. Again, non-essential functions. So, you know, if you normally have to, you know, clean the bathroom, well, that may be an essential function if that's part of your job, but it may not be. Or you have to handle cash. Well, I'm trying to think of a good non-essential function that might be COVID related, or greet people, you know, in some area, or go to people's houses for some small thing. Again, if this is not something that you have to do all the time, if it's not a big part of your job, then you may be able to have that eliminated. This can also come into play where, you know, you really need to telecommute, but there are certain non-essential functions that you couldn't do from home. Your employer might need to eliminate temporarily those non-essential functions in order to make it possible for you to telecommute. Temporarily transferring you to another job that doesn't have either, that again allows for telecommuting, or doesn't have the same risks that you would experience in your current job. And then finally, a leave of absence. I'm not going to get into it because it's a whole other presentation, but for those of you who are familiar with the Family Medical Leave Act or California Family Rights Act, sometimes you can use those as leave, but a lot of people don't qualify for those types of leave, and so you can request a leave of absence as a reasonable accommodation. The things to be aware of with that are that you need to provide an end date, and if that has to be extended later, it does. But if you go to your employer and say, well, tentatively I might come back on this date, or, you know, I'm not sure, or it's indefinite, the law is pretty clear that an employer does not have to accommodate that sort of vague request. Yeah, so, but the one thing to remember is unless your employer has some other policy, generally these leaves of absence are unpaid. And if either you don't qualify for family medical leave or California Family Rights Leave, or you've already used up those 12 weeks, your employer does not have to continue contributions to your health insurance during this leave of absence. Some of them do, which is great, but just be aware of that beyond any leave you have under the FMLA or CFRA, your employer wouldn't have to continue your health insurance coverage. So you may have to go on COBRA temporarily or something like that.
And then Rachel, we have a question, I think, related to leave of absence. Somebody asked, can workers ask for multiple days off based on not feeling well due to their disability? And do they need a doctor's note around this?
Yes, that is definitely something that you can ask for. So one type of accommodation could be intermittent leave. Going back to the migraine example, if you have migraines a couple times a month and need a couple of days to recover, or even if you need even less than a day, if you have to go to a doctor's appointment or a therapy appointment once a week for 2 hours every week, allowing you to do that can be an accommodation. Your employer can ask you for medical documentation showing that you need an accommodation. I think we'll talk more about what that looks like later on. But I will say, especially during these times, employers are really encouraged to accept, you know, emails or not emails, but you know, telecommuting appointments and any correspondence that comes through that. So they should be a little bit more lenient about what kind of medical documentation you provide given the circumstances. But yes, that can be an accommodation, and medical documentation for that can be requested. Okay, so we talked about this a little bit already, my apologies. Again, Family Medical Leave and California Family Rights Act, those provide up to 12 weeks of job protected leave, meaning you can't be fired. You have to be able to go back to your same job for your own serious health condition or for the serious health condition of certain family members. Unlike those laws, the ADA does not prescribe a strict predefined time limitation. There can't even be leaves that last for a year, courts have found. But as I said, it can't be indefinite. Another difference is if you ask for FMLA or CFRA and you are entitled to those, your employer can't say, you know what, it's really busy right now, I can't let you take that. They cannot, they have no excuse, you know, they have no undue hardship excuse for denying your request for that leave. That's not true under the ADA and FEHA. They can say, look, it's just not workable for you to take a leave that's that long. Are there other things we could maybe do? You know, what can we work out? Now, one thing I'll say is that employers try to use this undue hardship defense all the time, and it's a really high burden to show. An undue hardship is something that is going to significantly change the business's method of operation or be prohibitively expensive. And if someone asks for 2 months or 3 weeks of leave or, you know, whatever, and the employer would need to get a temp to fill in for them or something like that, they in all likelihood couldn't show undue hardship for that sort of thing. So that's important to recognize. Also, undue hardship is based, it's looked at individually by employers. So something that's an undue hardship for a mom and pop shop probably wouldn't be an undue hardship for Walmart. And then we talked about how the employer is required to continue benefits under the FMLA or CFRA, not under the ADA or the FEHA. So just to really underline this, if you don't qualify for FMLA or CFRA because you have less than 50 employees, or you haven't worked there long enough, or you know, have used up that leave, you do qualify, but you've used it, you can still take unpaid leave as an accommodation. And so that is really essential to remember. I can't tell you how many letters my clients have shown me from their employers, kind of form letters, that say, hi, you've taken FMLA leave for 12 weeks. 12 weeks ends Friday. If you're not at work on Monday, you will be considered to have abandoned your job. Employers should not do this. If you are taking leave for your own serious health condition, employers should consider the fact that that leave may need to be extended beyond what FMLA and CFRA require as a reasonable accommodation for a disability. The fact is, employers do not raise that. They sometimes either pretend or really are not knowledgeable about that. So it's so important that workers are knowledgeable and that they can assert their right, if they need it, to continued leave as an accommodation. That means when you're coming up on the end of your FMLA, before you get to that point, that you reach out to your employer and say, look, I'm not able to come back yet. I'm requesting, you know, X more weeks of leave or months of leave or whatever as a reasonable accommodation for my disability. If workers start the conversation, that's super helpful, because I mean, there may be a lot of employers that do, but those aren't the employers that I hear about. So also, again, remind any workers that you're talking with to make sure the doctor includes an estimated return to work date in the note. I had a doctor recently say, tentatively can come back in this date, and that's not good enough. They need to say, can come back at this date, or you know, out this many weeks. So those are important things to remember. So I'm going to speed up a little here because I just realized sort of the time that we're working with. But what is not a reasonable accommodation? Elimination of an essential job function. So again, if you can't do something that's essential to your job, then you know, your employer doesn't have to allow you not to do it. Lowered production standards. If everybody's required to make a widget that meets certain standards and you aren't able to do that, you know, that's not an accommodation to allow you to continue making the substandard widgets. And then employers don't have to provide personal use items that you would use at home as well, like wheelchairs or things like that. So who do you ask for an accommodation? Obviously someone, not your colleague, but HR or your supervisor or manager. You would have to disclose that you have a disability in order to be entitled to an accommodation. You don't have to disclose your diagnosis, and that's because California has really strong privacy laws. You should make this request verbally or in writing. You are not required to use any magic words like reasonable accommodations, but I always recommend that you do, and I always recommend that it be in writing. Even if you start out talking about it, send the follow-up email just so you have that paper trail. And you can request an accommodation at any time, but you should request it before your performance suffers, because employers are not required to forgive past performance issues, even if they were related to a disability before they knew about the need for an accommodation. Next slide, please. And we kind of talked about this, but can you go on? Okay. So what is the interactive process? You heard me throw around that word. It's a prompt, good faith, interactive, ongoing communication about accommodations. It's triggered by an employer's knowledge of disability. So if your disability is obvious, then your employer might have the obligation to talk to you about, you know, is there anything that we can do to help with this, you know, help facilitate this or help with an accommodation. It's a two-way street. Neither party can stop the conversation. If an employee stops it, then that's a defense for the employer to why they didn't provide an accommodation. Well, I never heard back from her about what she needed. And the process can restart if your accommodation isn't working. If you need another one, then that is something, you know, where you can restart the process. If we can go past this, I think I kind of spoke to these things. And yeah, I talked about undue hardship, but hopefully you all might be able to get a hold of this slideshow so that you can have a reminder of what that is. Okay, direct threat. So if an employer believes that whatever accommodation you're requesting would cause a direct threat to your health and safety or the health and safety of someone else, then they can deny that accommodation. And I apologize, I'm having a little bit of issue with my sound, so I'm gonna deal with that really quickly. Okay. Okay, can everyone hear me okay?
I can still hear you.
Okay, sorry about that. So in order to show a direct threat, the employer must show that there's a significant risk of substantial harm that cannot be eliminated or reduced by the accommodation. And the employer must have objective evidence, not stereotypes, assumptions, or fear, on which to pose the direct threat defense. So for instance, if someone has a service dog and it's a pit bull, and the employer says, well, some people are afraid of pit bulls, they're supposed to be mean dogs, that's not a reason for automatically saying that accommodation is a direct threat. You talked about how generally, yes, your employer can request you to provide a doctor's note. All that doctor's note needs to contain is a confirmation that you have a disability under these laws. Again, don't have to provide a diagnosis. It has to explain the link between your disability and the accommodation that you need. And also, if they have a good idea of what you need, a description of how that would address the limitation posed by your disability. So I always really emphasize this job accommodation network. It's a service provided by the Department of Labor's Office of Disability Employment Policy. It's a resource that you can call, a worker can call, an employer can call, and they can provide free advice and consultation about accommodations that might work really well for your particular job given your particular disability. They also have a lot of materials on their website about what limitations can be associated with different disabilities and how those different limitations can be accommodated. Okay, medical inquiries during COVID-19. We get a lot of questions about what people can and cannot ask about. And so to get to that, employers can ask employees if they're having symptoms of COVID and require them to stay at home if they do. They can take employees' temperature. They can require the use of infection control practices, masks, washing hands, covering sneeze, and again, can require use of PPE. And if someone needs an accommodation, like a different kind of PPE, then employers should do their best to accommodate that as well. Employers cannot ask whether an employee has an underlying health condition that places them at high risk. You can certainly disclose that if you need an accommodation for it, but your employer should not ask you that. Similarly, the employer cannot request employees who have underlying health conditions, or they cannot require them to stay home. But there is a direct threat exception where this would especially come into play if you have or think you have COVID. The employer might be able to require you to stay home while you await testing results or while you recover so as not to pose a threat to the rest of the workplace. Okay, how do you assert these rights? So if you are asserting a claim under the ADA, you would file it with the EEOC, Equal Employment Opportunity Commission. You have 300 days to do that after the date of the employer's bad act. You can look at their website, call that number to get started. If you're filing a FEHA complaint, and the reason why you might be doing this instead is because your employer is too small or you've missed your 300-day deadline, you have 3 years to file with the DFEH and can get that process started online as well. If you have both an ADA and DFEH claim, I generally suggest filing with the EEOC, and they will cross-file with the DFEH so that both of your state and federal rights are protected. If you don't file with these agencies, then you can lose your right to file in court regarding these particular this discrimination. So it's really important to keep these timelines in mind. Okay, any more additional questions?
Hi, yes, there is a question about the leave of absence and whether workers can collect uninsurance benefits during a leave of absence.
So if you're taking a leave of absence because of disability, you couldn't collect, you generally could not collect unemployment insurance because in order to qualify for unemployment insurance, you have to be able and available to work. So you have to be looking for a job, etc. But what you can apply for is state disability insurance. That's also administered through the Employment Development Department, who administers unemployment insurance. It's up to 60 to 70% of your weekly wages based on your income. And You can get it for up to 52 weeks. And as long as most employees pay into this fund, it's completely employer funded. So if your pay stub says CA, SDI, or SDI, then you likely have this benefit available to you. And so that is some wage replacement that you can apply for if you're on leave due to disability. So keep that in mind. There's more information on our website about state disability insurance as well.
And then another question, if a worker is COVID positive, are employers required to request for a confirmation from the worker that they no longer have COVID?
That's a good question. I think generally, yes. That can sort of be a matter of safety. I have seen, so basically employers can request testing as long as they do have to cover the time that you spend going to get tested and things like that, but they can require testing. So if an employer wants you to get a test to make sure you're free and clear, then they can do that.
And people can continue to submit questions. Are there any more questions that people have? There will also be an opportunity, if you're thinking about questions as we continue with the presentation. We'll open it back up again after Cheryl presents for Q&A, and you can go ahead if you thought of a question that you couldn't think of before, you can ask it at the end, and Rachel may be able to answer that question.
Thank you.
Thank you. So I guess since we do not have any questions coming up, let's go ahead and start with Cheryl. Also on this next slide, we do have a link to Legal Aid at Work's COVID-19 FAQ link, and also more samples and videos about the rights of workers with disabilities, and also the number to Legal Aid at Work Disability Rights Program hotline. I also sent in an email last night, some samples that Rachel thought would be helpful for you all. And if you did not receive that email, please email me to let me know. Thank you.
Okay, thank you guys. Rachel, that was very helpful. I appreciate that information you gave us. My name again is Cheryl Wallach, and I'm a partner at Ford & Wallach, and all I do is practice workers' compensation. I only represent injured workers. So what I'm going to be talking about is generally how does COVID-19 play into a workers' compensation claim. So we can go to the next slide. So the basic rule is if a person who is at work contracts COVID-19, they absolutely have a right to file a workers' compensation case. When I go to court, I'm basically arguing that an injury is work-related. And what we use when we go to court, a judge will say, Cheryl, is this injury AOE, COE? That means, did it arise out of the employment and during the course of employment? This is what we need to prove when we go see a judge. So anybody who gets COVID-19 at work has a right to file a claim. In fact, our California Insurance Commissioner, Ricardo Lara, in the beginning in March, did a proclamation stating undocumented workers, people who do gig economy, and anybody who contracts COVID-19 at work does have a right to file a claim. With that said, though, not every claim is worth pursuing. Not everyone does need to file a workers' compensation claim if they contract COVID-19. As we know, hopefully, 80% of the people are going to make a full recovery, and in that case, it may not be worth the time or the energy to file a workers' compensation case. Next slide. What we need to prove is causation, AOE, COE, that you contracted the virus at work. Generally, the flu and the common cold are not considered to be a work-related injury, even if you contract it at work. But coronavirus or COVID-19 is so different, it's so highly contagious and so debilitating that it is considered to be an industrial injury. What a worker has to do to show that the injury or the COVID-19 was contracted at work is the worker has to show that they were at an increased risk compared to the general public. That's how we prove AOE COE. I'm on the board of the California Applicants Attorneys Association. I'm on a board of governor, and we're working with a coalition of unions on a legal presumption, which means to favor one side or another in proving that a person contracted COVID-19 at work. There are different types of presumptions, and we're going to talk about that in the next slide, but a legal presumption is one that favors one side or the other in regards to the law. Governor Gavin Newsom gave us an executive order back on May 6th. It is good between March 19th, 2020 through July 5th, 2020. So in effect, 107 days. He gave us a rebuttable legal presumption for people who contract COVID-19. So that favors the injured worker, but it gives the other side a chance to rebut or to fight back, saying that it is not work-related. This executive order is available, again, if you work between and contract COVID-19 within 14 days from when you are at work, and you have to have a positive test, and within 30 days it has to be confirmed by a doctor that you do have COVID-19. And then it gives the injured worker a rebuttable presumption that they contracted it during work. There are three types of presumptions that we have. The first one is what Gavin Newsom gave us. And again, we're trying to work with legislators who are in session right now up at the state capitol on a conclusive presumption. But the rebuttable presumption gives the injured worker the assumption that they contracted it at work. And then it gives the other side an opportunity to rebut that. So it gives the other side a chance to fight against what is proven to be an AOE COE or an industrial injury. A conclusive presumption is one where it basically closes the book on causation. Once I prove that I have the virus, the other side doesn't get to rebut it, or the other side does not get to fight that issue that I did contract COVID-19 at work. The final presumption that we use in our office is really one that I'm using day in and day out because it makes sense. It's called the common sense presumption. It's something we sort of made up in our office. It's not one that's legal. But if a person's at work and they're not social distancing, or they're dealing with the general public, or they're with somebody who also has the virus, that's a common sense type of presumption that we can produce and show the judge that, again, the COVID-19 was contracted at work as AOE COE. Again, going back to Gavin Newsom's executive order, it was good for 107 days. It's rebuttable. It's only valid through March 19th through July 5th. And we don't know what's going to happen. There are three scenarios that are going on in the California legislature at this time that we don't know what they're going to agree to, if any, but we're hoping that we will have a presumption that is not rebuttable. Next slide. So now, assuming somebody contracts COVID-19, what do we need to do? There's three things. What we say is you need to document some more, and then you need to document some more. We need to document because we're going to be going in front of the judge either 6 months to a year to maybe even 2 years from the date that you contract COVID-19. So it's really important that we have information to prove, one, that you contracted the virus at work, one, that you contracted the virus, two, that you contracted the virus at work, and three, what are your symptoms and what are your disabilities that you have? So who needs to document? First, the injured worker should document. We're asking the injured worker to keep a diary from once they realize that they have COVID-19. Who were they around at work that they believe also had the virus that gave it to them? What sort of social distancing or rules of protection was the employer providing? Were they working in an essential job and dealing with the public? Were they the only ones in their family that went to the market or went outside the house except for work? Were they the first ones that contracted the virus at their house, or did they contract it at home from somebody else? Because obviously if they contracted it at home from somebody else, it would not be a work-related injury. So the injured worker can keep a diary of their symptoms as well. The union or you as an advocate can also document. We're working with an employer right now with the union that had many emails back and forth early on in March that documented all of their concerns regarding what they were not doing in regards to protecting their employees. We're also working with them because about 60 of their employees, and they have approximately 300, but about 60 of their employees have contracted the virus. So that's able to, I'm using that information to be able to show that all the injured workers that I represent obviously contracted it at work. They also can just keep track of how many people have contracted the virus overall, even if they're not being represented. The doctor also can be one that can document things. The doctor can document how the injured worker thought that they contracted the virus, and also what their symptoms are. What sort of problems are they having that are related to the virus? The more documentation we have, the better we can do to prove that, one, it arose out of the employment and during the course of employment, and also to cover all of the symptoms that an injured worker has due to the virus. Medical treatment is the most important benefit under workers' compensation. That's probably the most important benefit and most valuable benefit that a person can get if they have a work-related injury, whether it's a back injury or COVID-19. However, as I indicated in the beginning of my presentation, not every workers' compensation case of COVID-19 is necessarily one that you want to pursue. Many people ask us, what is the best thing that I can do for my case? And my answer is, don't do what's best for your workers' compensation case, do what is best for you. Without Governor Newsom's executive order, the employer has 90 days to investigate a claim to determine if they're going to accept or deny the case. With the Gavin Newsom's executive order that was good for the 107 days, they only have 30 days to investigate the case. But as you know, by the time you report the injury gets sent to the claims examiner. They open up a file and determine if they're going to accept or deny the case. As you know, because of the fact that COVID-19 is such a devastating type of virus, you could be on a respirator by that time, or you can be dead. The time limit to file a claim, which we call the statute of limitations, is 1 year from the date that you contract the virus. It can even be extended beyond that if you don't know that you've contracted the virus at work. But at a minimum, you have 1 year to file an application with the Workers' Compensation Appeals Board. So it's our position at our office that the first priority that you want to do is get your medical treatment on your own. Don't wait for the insurance company to open up the claim. Go ahead and get your treatment. If you feel that you're not getting better, if you're one of the 20% that are still having problems, then of course you definitely want to consider filing a workers' compensation case. Our office has been talking to tons of people who have contracted COVID-19, and we're happy to be a resource for anybody who wants to talk about it, whether or not they should file a claim or what their rights are. Not every workers' compensation case, one, needs to be filed, and not every workers' compensation case needs an attorney, but we're happy to be a resource for you. But we want to make sure that you remember that the first important thing is to go and get your medical treatment, and don't wait for the workers' compensation case to begin. There are 5 benefits under workers' comp, and as I said, the first benefit is the most important, which is the treatment. The second one that Rachel sort of alluded to is the time off when you're not able to work. That's considered to be temporary total disability under workers' compensation. Temporary total disability is determined by a doctor. Either that you're totally temporarily disabled or you're partially temporarily disabled, and the employer cannot accommodate those work restrictions that are temporary. If they, under workers' compensation, not under what Rachel's law is, but under workers' compensation, if they can't accommodate the temporary disability, the work modifications, or you're on total temporary disability, you're entitled to 2/3 your average weekly wage. And for injuries occurring in 2020, the maximum you're entitled to is $1,299.43. It's basically the same rate as state disability. It's 2/3 up to the cap. The difference between workers' comp and state disability is that workers' comp's good for a maximum of 2 years within a 5-year period, so you can go off and on work. back and forth. And state disability is good for a maximum of 1 year. The next benefit under workers' compensation is the permanent disability that you have once you've reached a plateau or you're at maximum medical improvement for the virus. So you, as you know, 80% hopefully will recover, but the 20% won't, and they may have serious permanent disability due to the virus. It can be something as lung problems, brain or cognitive problems, amputations, depression and psychiatric injuries, many different types of disabilities that you can have due to the virus, and we need a doctor to document all of those. We take every body part or every type of condition, and that goes into a formula determined by a doctor and the California Labor Code, and it turns out to have a level of permanent disability. So depending on your level of permanent disability, you're entitled to a certain amount of payments payable at $290 a week until the level of disability or the number of weeks is paid out. And it's determined by the percentage of disability. The number of weeks you're entitled to is based upon the percentage of disability. If you're 99% disabled, you're entitled to approximately $260,000 in payments of $290 a week. So as you can see, no workers' compensation case is worth losing your job over. If you can physically get back to work, it's always our recommendation that you get back to work. If you can't physically go back to work, you're entitled to a job retraining voucher. It's a $6,000 voucher for job retraining. It goes to a school. However, once you're entitled to that voucher, you're also entitled to another $5,000 from the state of California from the Return to Work Fund. So you take that voucher, you go online and apply for the $5,000 Return to Work Fund. But for basically $11,000, $6,000 of it to a first job retraining and $5,000 cash, you just lost your job if you can't physically go back to work. The final benefit with COVID-19 is one that we're seeing more and more is death benefits. Your dependents at the time of you contracting the virus are entitled to death benefits. You have to be a dependent, not an heir, so somebody cannot just list you as in their will as somebody to receive money from their estate. It has to be somebody who is dependent on the person's support that dies due to contracting COVID-19 at work. Your dependents, depending on how many you have, are entitled to anywhere between $250,000 to $350,000 payable at the temporary disability rate, that 2/3 your average weekly wage. Next slide. Psychiatric injuries with COVID-19 are very legitimate and very valid claims. People have psychiatric injuries because they're afraid they're going to contract COVID-19. They're afraid once they've contracted COVID-19 that they're not going to get better. People are afraid that once they've contracted COVID-19, they're going to get it again. And the most devastating type of psychiatric injury that I have many cases with this type of injury is people that contracted COVID-19 at work, came home, have survived COVID-19 and basically have a full recovery, but unfortunately they have given the virus to a loved one at home, and the loved one has passed away due to contracting COVID-19. This is probably the most valid and legitimate type of psychiatric injury that I can imagine, and unfortunately with COVID-19 we're seeing many of these types of cases. There are non-COVID-19 claims that people have a right to file that we just want to make sure we mention. People who are furloughed but have had injuries before they were furloughed are entitled to file a workers' compensation case. Many people continue to work through their disability or their injury, or the employer is accommodating them. They still have a right, even if they've been furloughed, to file that claim within workers' compensation at the Workers' Compensation Appeals Board. We have cases where people are working at home. We have people who work for instance, the LAPD. She's an investigator. She was ordered because of her increased risk and because she's at over 80 years old. She brought boxes home to work on her investigations at home, and she tripped over the box and had major fractures to multiple body parts. That is a work-related injury that even though they're working at home, but it arose out of the employment and during the course of employment. Many people have pre-pandemic claims, and a valid claim is a continuous trauma claim that I talked about earlier, where many people will work through their injuries because they have to provide food for their family, and they're able to, or they're able to be accommodated for their injuries. That's called a continuous trauma claim, and the best example I can give is somebody who gets carpal tunnel at work due to day in and day out wear and tear of their injuries. And even if they're not working now, or if they're working from home, they may have what's called a continuous trauma or a cumulative trauma, which is a repetitive work type of injury. It's basically the day in and day out type of claim. These pre-pandemic claims are also valid claims that can be filed even though we're in the midst of a virus. The final issue, besides those 5 benefits that we talked about under workers' compensation, is something called a serious and willful misconduct of the employer, which is under the California Labor Code Section 4553. That's when an employee is forced to work or is working in unsafe work conditions. If an employer is not providing a safe work environment, not social distancing, not providing protective equipment, not providing an avenue where people are not walking in the same area, not asking people to wipe down their area, those types of claims, that can be considered to be a serious and willful misconduct claim of the employer. We don't know what a judge is going to do in a couple years against the employer regarding this regarding the pandemic, and whether or not the employer is acting something akin to like an OSHA violation. I just read about 2 days ago that OSHA is considering having some sort of rules regarding the conduct of the employer, and if the employer does violate an OSHA violation, that could be also considered to be a serious and willful misconduct of the employer. This is a claim that is basically punitive against or to punish the employer. A California Labor Code Section 4553 serious and willful misconduct claim is something that if somebody contracts the virus and the employer basically says, I don't care if you contract the virus, I'm not doing anything with this, that is a claim that needs to be filed. The time limit to file a Labor Code Section 4553 claim is 1 year from the date of the injury. That means it has to be filed with the Workers' Compensation Appeals Board within 1 year. 1 year and 1 day is too late. We can't extend that time limit like we possibly can extend the regular application for a regular claim. So this is a strict timeline to file this. If a judge determines that an employer did violate Labor Code Section 4553, the damages are quite severe. Every dollar that the insurance company or employer pays on the regular benefit, meaning temporary disability, permanent disability, treatment, all of those benefits. So for every dollar that the insurance company spends, the employer themselves has to write a check for 50 cents to the injured worker. So if the injured worker goes to the doctor and has to see the doctor and there's a bill of $40, the employer has to pay the injured worker directly $20. So it is quite a harsh claim if an injured worker would prevail, but this is something that needs to be considered to determine if it should be filed against the employer. There's something about our office. We are considered to be essential service workers. We're organized by Teamsters 986, and we have an agreement that we are considered to be an essential service worker. Our office is open. We're happy to be a resource for anybody who has any questions. We are in Los Angeles, but we can answer any questions in the state of California. And these are just pictures of some of our employees working. And then you can go to one more slide. And we actually, my partner, Scott Ford, and myself are teachers at Los Angeles Trade Tech College, and we teach every year there. And I'm also a member of AFT based upon that. And we have written that's our textbook that we use at the Trade Tech College that gives information regarding workers' compensation. You don't have to be a union steward to use this resource, but we recently updated this for COVID-19 claims. So if anybody's interested in getting a copy of the book, you just need to email jswanson@fordwallach.com. He's our labor union liaison, and he's happy to send you a copy of the textbook that's been updated.
So we got a question, and people can keep putting in questions. So somebody asked that they've read about employers pushing the responsibility back on the worker by claiming they got it in their community. I would also argue that racism also plays a role in those assertions. How to like, you know, prove they got it at work, I guess maybe to rebut that sort of claim.
Well, remember, all we need to show is that there's an increased risk for it to be an industrial injury. And then we're going to see what the legislation does regarding rebuttable or about the presumption, the conclusive presumption. However, with that said, whether or not we have a presumption or not, it's my opinion that it's sort of a no-brainer. And I think somebody put in maybe in airlines, if they're working and you take every case by their facts, if a person only goes to work in their household and no one else in their household contracts the virus, or they're the first person to bring it home to their house, and the only thing that person does is go to work, that's whether or not the employer is going to fight that or not, that's a case that I would take to trial to show that it is a work-related injury. So again, everything you can do to document, and just because an employer says it's not, doesn't mean that they're correct. I mean, that's what we fight all the time on, is we fight these types of cases constantly, that they're saying that it was not a work-related injury. And again, it's fact specific, but the more facts you have on your favor showing the increased risk, the better. You don't have to say it's 100% certain and you got it on this particular date. You just need to show that you have an increased risk.
Great. And then there was another question in the chat. It says, how can a person declared recovered from COVID-19 when the condition is only treatable? Once infected, there is no cure. Once infected, you will always have COVID-19 in your body. That can reactivate, similar how chickenpox can reactivate 30 years later as shingles. I'm not sure.
And it sounds like, even if I say there's a full recovery, is that certain? And if you're concerned about that, and you want to keep your future medical care left open and litigate that may be something that you want to do, is file that claim to protect any future treatment you may need. You may not have any permanent impairment that's detectable right now, but it depends. We're learning more and more about the virus every day. I mean, there was about a month ago, it was once you've gotten the virus, you couldn't get it again. And we're learning that may not be true. So as things are evolving, we're learning more about the virus. And you're absolutely right that if you feel that you may need future medical care in the future and you're not having a full recovery, then it may be worthwhile to pursue a workers' compensation case to get that valuable future medical care.
And does anybody have any more questions that they'd like to ask either Rachel or Cheryl?
If not, I have some questions. So Cheryl or Rachel, I have questions around retaliation. So can you address what happens if a worker gets injured as a result of COVID-19, reports their illness, and then directly following that, they're either fired, demoted, or transferred?
I can answer it regarding the workers' comp issue, and then Rachel's is going to be a lot longer. It's illegal for anybody to discriminate for filing a workers' compensation case, and that's a Labor Code Section 132A. And then I know Rachel's going to go into the bigger issue, so that's all yours, Rachel.
Okay, thanks. So it's actually a little bit of a complicated question, and again, so when you're looking at retaliation under anti-discrimination laws, in order for it to be unlawful, it has to be based on the fact that your employer retaliated against you for taking a protected act. So if you were to tell your employer that you had COVID and your employer were to terminate you, that could be, I mean, there's a couple, actually we've been thinking about this a lot, so it's a little bit complicated, but there's sort of a couple ways to look at it. If you say, I need time off work because I have COVID, I don't want to spread it, then you could be covered, and then if your COVID manifests into something that's considered a disability, you could be covered by the retaliation protections under the ADA and the FEHA, meaning that you were basically disclosing a disability to your employer for the purpose of getting an accommodation or what have you, and were terminated. The more difficult question is when it's asymptomatic. There, I think we would try to maybe argue that it was still a disability because of long-lasting impacts, but that is still very iffy. The one other thing you might consider, California does have a claim for wrongful termination in violation of public policy. So it's pretty vague, which can be a good thing. So basically the argument would be, we have all of these protections in place and to prevent the spread of COVID, you are disclosing your exposure or your contraction of COVID to your employer in the interest of furthering this objective to protect public safety. And in turn, your employer retaliated against you for doing that. I think you have a good argument that that's against California's public policy. You don't want to discriminate or retaliate against people who are trying to take actions to do things that California would want them to do. So it's kind of a gooey claim. It's always better if you have, a claim under the ADA or FEHA as well. But it's sort of a fallback if you don't have symptoms that rise to the level of disability, and might have trouble making the argument that you were exercising any sort of disability-related rider protection. Hopefully that made sense.
Yeah, great. Thank you so much. I wanted to ask Gadine, are you seeing any more questions in the chat or Q&A?
Yes, let me pull it up. So this is for Cheryl. What about workers that are careful at home, but they work at more than one job? I'm thinking specifically about nursing home workers. How would that work? What stops employers from putting it back on the worker or say they got it at the other work site?
Well, nothing stops a worker or employer from fighting the claim. What I would probably do, depending on, because that transmission is usually about 2 weeks, I file it maybe 3 weeks, is one, I would list the last day and the last employer that they worked at on the last day that they were able to work. I list them as a claim. Then I also file a claim as a repetitive type of injury, that continuous trauma claim, because we don't know exactly when they were able to contract the virus and what the exact day, the exact moment. So I would also file the claim for the last, let's say, 3 weeks, and list all the different locations or employers. If it's a same employer but different locations, it doesn't matter, it's still the same employer. But if it's different payroll companies or many different employers that they work at, I would file the claim against all of them during that 3-week period. And a judge could say it's joint and several liability, or they may pick one and let the other employers fight it out. I don't care. I'm saying it's a work-related injury. Let them prove it's not during their coverage or during their employment.
Awesome, great. Any more questions, Karine, that you're seeing?
Yes. For Cheryl, you briefly mentioned a 132A claim. Could you explain what that is? Thanks.
That's a claim within the Workers' Compensation Appeals Board, and it needs to be filed within 1 year from the date of the discriminatory act. So it can be whether you contracted COVID-19 and they fire you and you say it's work-related. It's only regarding a work-related injury. And the reading, the summary of a Labor Code Section 132A is something stating basically you cannot be discriminated against for filing a workers' compensation case. You can't have a demotion, you can't be fired, they can't treat you any differently. If you file the 132A and you prove that they're discriminating against you, that they, for instance, if they're having a massive layoff and you happen to have COVID-19 or a work-related injury, and they're laying off half of their employees, it's going to be hard to prove that they're actually discriminating against you for filing a workers' comp case. But if you can prove that you've been discriminated against, then you could have up to $10,000 in penalties and reinstatement and back wages. So we always file if we believe you're discriminating. We believe that there's a 132A. It has to be filed within 1 year, just like that serious and willful claim, the 4553 Labor Code Section 4553 claim. But we file that within the 1 year from the date of the discriminatory act. But we usually also refer you to an employment attorney to determine if there's something else going on, as ADA or FEHA, some sort of discrimination type of case as well in the civil court as well. Usually the damages are better in civil court if you can prove it, but we also, and they also include the 132A when they're filing that, but I have to file that within the workers' comp arena as well.
All right, and we're getting close to the close of the session. I have one final question. It's hopefully an easy one. Cheryl, are you seeing the Department of Workers' Comp? They usually have these information and assist office that you can go to now, you know, obviously you can't go to them or it's more difficult. Are you seeing a ramp up of maybe virtual assistance or telephonic assistance? How helpful has the Information Assistance Office been?
Well, I see the Information Assistance Office. When I say see, I use that term loosely. When I'm right now, the court is only by telephone. We call in with multiple judges on multiple lines and we're talking to the court and getting quick dispositions or asking them to resolve something or setting for trial. So I see the information assistance officers on the line helping injured workers. So they're available. I don't think they're actually at the court. I think there's reduced people at the court working and most are working from home. And there could be an email that you can send to them as well. The other thing is though, that we're going to be having regular trials and hearings by video conference soon. And that should be taking effect within the next couple of weeks. So I think that will also be assisting people who have some sort of electronic device. And it's supposed to be very easy. Any electronic device will work, is what they're saying, in order for an injured worker to contact the information assistance officer for help. And just so you know, an information assistance officer is a non-attorney that works at the court that it can help you answer any general types of questions.
Yeah, and you can find the number for your local information assistance office on the Department of Workers' Compensation website.
Right.
So we are at the end, a little bit over. I wanted to thank Rachel and Cheryl for joining us. I wanted to let you all know that we do in-depth trainings and a whole lot of other amazing things. So please connect with us if you want to join our coalition work. Or receive an in-depth training specifically for your workforce. We are doing bilingual trainings that we'll be recording, that will be available for recording to access later. I think we're going to try to coordinate those in September. Contact us if you have a workforce that might be interested in attending that. Again, we have multiple coalitions and there's just so many ways that you can advocate for your workers by working in solidarity with us. There will be an evaluation that will pop up soon. We encourage you to give us feedback so we can know how to best structure these trainings in the future. So again, let me welcome Cheryl and Rachel back. So all of y'all can see their lovely faces. And thank you so much for joining us, Cheryl, and for your amazing work during this really trying time. And Rachel.
Thank you very much. Everybody be safe.
Yeah,
Yeah,
thank you.
thank you.
Bye-bye.
Bye-bye.